much, and I'd like to call to order this specially called meeting of the Investment Committee. We have one item we will be dealing with in a minute, and so we will have the opening legal statement, please, Vicki.
Yes, sir. For the record, I want to note that this is a special called meeting of the Investment Committee of the Kentucky Retirement Systems. This meeting is being broadcast via video teleconference pursuant to Kentucky Revised Statute Section 61.826 and may be viewed by the public at the Kentucky Public Pensions Authority offices located at 1260 Louisville Road, Frankfort, Kentucky. It is also being broadcast to the public via Facebook. I ask if you are speaking and not appearing by video, please identify yourself before talking. Please ensure that you are on camera when making or seconding a motion or casting a vote. In the event this meeting becomes disconnected from Facebook, we will attempt to reestablish a connection. If a connection cannot be reestablished within 30 minutes, the meeting will be adjourned and rescheduled to another date.
Thank you very much. Sherry, will you do a roll call for us, please?
Yes, sir. Mr. Lane?
Here.
Ms. Bova?
Here.
Ms. Hampton?
Here.
And Ms. Thompson?
Here.
Thank you.
Very good attendance today. Thank you very much. Do we have any public comment?
No, sir, no public comment today.
All right, then we'll go quickly on to the meat of the meeting, the single item we have on the to-do list, I guess. Carrie, would you like to introduce this section, please?
Yes, Mr. Wayne, thank you so much. Thank you all so much for being here on this Wednesday afternoon, pretty late in the day. I appreciate your time and consideration for this important matter. Before I get started, I'd like to note that we're joined here today by one of the TKIP interns. This gentleman, Brandon Nielsen, is the Office of Legal Services intern, and he will be joining us and watching the discussion today around our policies. Brandon, can you say hello to everyone briefly so they know who you are?
Yes, of course. Thank you so much for letting me join. I really look forward to being part of this meeting with you guys. Thanks for letting me join.
Thank you,
Nice to have
Brandon.
you.
Thank you.
Thank you.
Now I'm going to put Sherry through her paces today, I'm afraid, and start towards the end of the materials on PDF page 56, if you don't mind. And I am going to talk us through a high-level overview of the proposed updates to the Kentucky Retirement System's investment-related board policy. Feel free to jump in with questions at any time. I'll take the next page. The bases for the changes recommended today by myself are in collaboration with our team here at the KPPA, including, of course, Steve and the investment team, as well as Vicki Hale and the Office of Legal Services team. But these proposed changes also addressed industry, public pension plan, best practices, internal audit findings, and reflect that we are right in line with a recent study of the 50 largest public pension plans in the United States. I'll take the next slide. So right now, the Kentucky Retirement Systems, its investment-related board policies include the investment policy statement. Oh, do I hear someone? Okay, I'll keep going. And 9 other ancillary policies. And what we're proposing here today is to condense that into one statement of investment objectives and policies with 2 other standalone policies that are somewhat related to investments. One is securities litigation and the other is securities trading. I'll take the next slide. So this slide represents a comparison of the Kentucky Retirement System's current IPS, investment policy statement, and the proposal of the consolidated statement of investment objectives and policies. So you'll see that both are going to have the board's purpose and philosophy and objectives stated. We've added a definition section. We've gotten more specific on those roles, responsibilities, and delegation. You've still got a clear asset allocation policy, clear benchmarking and performance standards, clear guidelines and restrictions to ensure diversity of investment. And you'll see that the proxy voting policy and the investment procurement policy are folded into this comprehensive statement of investment objectives and policy. Still got that certification. And finally, we've added a revision history appendix for each policy or chapter, if you will, so we can keep a little better track of the changes over time to this document. Take the next slide. So if the investment committee is willing to recommend to the board that that the adoption of the proposed changes to the KRS investment related board policies, what you'll see is the investment security lending guideline, brokerage policy, manager and placement agent, statement of disclosure policy, and the investment transaction procedures policy are all going to be delegated to the investment staff to implement and implement procedures and carry out those tasks. You'll see that the investment proxy voting policy, as well as the investment procurement policy, as previously stated, are folded into this consolidated document. The real estate policy will be repealed entirely. My understanding from talking to Steve and other folks in the investment team is that's a legacy policy that the KRS board adopted when it started to invest in real estate, but is no longer necessary. And then the securities litigation policy and the securities trading policy will just remain as is without changes at this time. We'll take the next slide. To hit the big changes that are to this board's investment-related policies that are proposed in this statement of investment objectives and policy, it recommends and proposes that some decision-making below a certain threshold is delegated fully to the KPPA investment staff. Now, before we get too far down that rabbit hole, I want to note that the reporting structure, monitoring, and ultimate fiduciary duty to oversee the investment and management of these assets remains with the full Kentucky Retirement Systems Board of Trustees. Some other notable changes are potential additional guidelines and other changes to the proxy voting policy. Nick Zeiker from Reinhardt is going to talk a little bit more about some of his recommendations in that area in just a few moments. And then the removal of more procedural elements from the procurement policy and a focus on big picture policy overview in that area. I'll pause here if anybody wants to talk through any of these big splashy changes. If not, then I'll go to the next slide, please, Sherry. The reason for those three bigger picture changes regarding the delegation of certain decision-making to specifically the CIO and in his or her absence, the deputy CIO, and sometimes other investment staff. The reason for that recommendation is that this delegation to experts in the area of investments is an appropriate exercise of the board's fiduciary duty. It minimizes risk for voluntary board members by, again, delegating to those experts. It helps voluntary board members avoid exposure to material non-public information, which can cause a person with material non-public information regarding certain information that may be relevant to an investment can open up some risk related to insider trading SEC level requirements, and that kind of helps the board members avoid that. And it also improves the agility of the KPPA investment staff to pursue investment opportunities for the Kentucky retirement system. The proxy voting guidelines the proposals there are related to an update to reflect kind of more modern corporate governance issue and improve the board's fiduciary oversight, which I'll leave that to Nick to talk about here in a moment. And then the procedure removal from the investment procurement policy, again, is just a best practices to have your policies be a little more high level, and then the procedures to implement that policy. I'll take the next slide. But at the end of the day, before turning it over to Nick to talk through some of his approach in recommending changes to the proxy voting policy, I wanted to note that the Kentucky retirement system Board of Trustees will continue to set the asset allocation, set those performance objectives, benchmark what it expects from its investment. It sets restrictions and guidelines so that the assets remain diversified and risk is controlled appropriately. The board is going to set those proxy voting guidelines. The procurement policy is required by state law, and the board and its investment committee remain responsible for the monitoring and oversight of investments of trust assets. The board, if it doesn't like what it sees, can change any part of this policy at any time, including delegation of certain decision-making authority to the KPPA investment team. And ultimately, under this policy and at all times, the trustees remain as the fiduciaries. And with that, Sherry, if you could go to PDF page 49, I'll introduce Nick Zeiker from our outside counsel at Reinhardt to discuss his approach in recommending some updates to the Kentucky retirement system's proxy voting policy.
Thanks, Carrie. As Carrie said, my name is Nick Zeiker. I'm an attorney with the firm Reinhardt, Berner Van Duren. We're located in Milwaukee, but we have a global client base of many public pension plans, authorities, et cetera, familiar with your team. So just a little bit of background from my view. Carrie had asked me to take a look at the existing proxy voting guidelines of the KPPA. And I provided as part of that review some comments, and we discussed some questions as to how we can bring the proxy voting guidelines, just a bit of a refreshment and an update to account for modern sort of practices surrounding proxy voting. So I guess unless there are any comments or questions at the outset, my thought was to walk through the changes proposed here in the memo that Carrie had prepared, and just provide some brief rationale and basis for including. And again, I really do, I'm happy to address questions or comments as they come up. So if I'm speaking and you have a question or comment, feel free to interrupt. I can talk forever if I'm not leashed in some way. So I guess moving to the first, the election of directors guideline. So we've made a few recommendations here. You'll note in the lead-in language, and this is a theme throughout the proposed revisions, the proxy voting guidelines are intended to effectuate the board's duty to vote its proxies consistent with its overall fiduciary duties of care and loyalty to the plan participants. And that means, from my perspective, allowing the flexibility to adapt and react to unknown and potentially unforeseeable circumstances. So I say all that to note that in the first paragraph there, I've included in most instances, and that's a theme that you'll see throughout the proposed guidelines. These are meant to be sort of a guide, but are not to be adhered to unthinkingly and uncritically. There's a need for flexibility and adaptation, and we've drafted these in order to accommodate that. So as an overall matter, Obviously, we've retained the existing language that in most cases, the board is going to, we would expect the board to vote in favor of management's recommended slate of directors. There are some exceptions, and I'll go through these briefly. Number one, in the case where a proposed slate or number of directors are insufficiently independent, that may be a case in which the board may wish to withhold or vote against the slate. I think consistent with peer practices, we would typically expect between a majority and 2/3, and we've noted that for further discussion amongst the board. That really is sort of a board level decision. Either are consistent with general peer practice, somewhere in that range. We would also think that in certain circumstances where the average tenure of boards, those tenures can creep up quite to be quite high. And ideally, what you want is a mix of experience and, for lack of a better term, new eyes on the issue. So, in certain cases where the board is overly skewed one way or the other, that may be a circumstance where deviation from the standard is desired. And then again, if there are situations in which the board determines that certain directors are not able to devote their full time and energy necessary, this really gets to an overboarding question. Once somebody gets experienced, but if they serve on 5, 6, 7, 8, I've seen up to 12 public company boards, that's an enormous time commitment. And there comes to be a point, in reasonable minds can differ, but I think there certainly is a point where there's a question of, well, is this individual really able to devote the necessary time and attention to the company at hand here? So I had added those proposed exceptions there to address some relatively standard matters. I'll pause for questions if there are any. All right, hearing.
Nicholas,
Sure.
back on the exceptions here, it says the board may consider withholding its vote. That's the KRS board or?
Yes, that's correct.
Okay.
Thanks, Carrie. That was my thought, but glad to have the confirmation.
Yes, if you in this document, if you
shareholder.
see the board capitalized, that's going to be the KRS board. And if we're talking about a corporate board, it will be lowercase board of directors.
Okay.
Okay. I'm hearing nothing further. I'll move to Roman numeral 2, the appointment of auditors. So again, this is a fairly standard provision here that we've updated for. Company boards are required to include a line item vote on the auditor, and it really is in nearly all circumstances a formality. However, there are some circumstances in which it has been demonstrated in cases where the auditor may, due to a very long-standing relationship with a company board or for other reasons, may have some sort of undue influence and may not be sufficiently independent to provide the required audit. So really what we've done here is tried to build in just a bit of flexibility. So in those sort of rare outlier cases, the guidelines would permit the board to either withhold or vote against. I would expect in practical terms that would very rarely, if ever, come up. But I think that the flexibility is appropriate here. Moving to Roman numeral 3, changes in board structure. So what I did here when reviewing this, there were a number of these provisions that were already covered in the existing proxy voting guidelines. What I've tried to do here is kind of condense and bring together various different issues or board structural issues that commonly come up when analyzing or determining how to vote proxies. So typically, we would expect the board to vote in favor of proposals that support board effectiveness. That's why we vote. And independence. An independent board has been shown to be crucial to providing that sort of independent check on management, particularly in the public company scenario. Some common issues would be, voting on whether to appoint an independent board chair or lead director, typically a favorable provision from the perspective of a shareholder. B, separate the chair and CEO roles. minimize the conflicts between management and board service. Typically, it is best practice to have those roles separated, although, again, there may be circumstances in which the board determines in its discretion that that is not appropriate. C, to form or implement board committees. I've listed some standard committees here: audit, compensation, nom-gov. These are committees that we would expect to see at the board level, and they generally improve functionality. So we would expect the board to vote in favor of those. Declassified boards or eliminating staggered elections. It is best practice to have directors stand for election every year. And again, typically a formality, but to the few companies that still employ staggered boards, that would be best practice. And then, again, rarer and rarer as we go on, as time marches forward. But in the event there's a proposal to implement majority voting rather than a plurality voting system, in which there could be a case in which a director receiving a single vote would be determined to be elected. In that case, the majority standard is consistent with best practices, and we would expect the board to vote in favor of that. And then again, as always, an exception to the rule. Proposals that seek to limit individual director term limits or board term limits as a whole, we generally disfavor those, and it seems a little bit counterintuitive. As I just said, you want to have a balance of experience and new eyes, but building those sorts of term limits into the corporate documents themselves, and it's been found in a number of studies that actually decreases the functionality of the board. You really, in some cases, do need that person with the 20-25 years of experience to sit on the board, and prohibiting that outright is usually disfavored from the perspective of a shareholder. I will pause again, and hearing no comments, I'll move on. There was language in the prior proxy voting policy regarding classified boards. So we had addressed that up top. We didn't think it was necessary to include as its own separate section. Again, these are becoming rarer and less frequent, but it really is a board structural issue rather than a standalone item from our view. Executive compensation. So again, companies. I see a question, a hand raised from Lynn.
Yeah. When you're on mute, and when Ms. Hampton has pointed out a typo in that last exception, it should read, the board may consider voting. Sherry, you were on the right page. It's the last exception noted in the right column under executive compensation. It said the board may consider voting against compensation plan that insufficiently address clawback of unearned executive compensation. That's how it should read. And I will fix that should the board wish to adopt this language, or the investment committee rather recommend adoption to the board. Getting ahead of myself here.
Carrie, I kind of, when I sent you that, I said, it's a nit. You don't have to say anything about it.
Oh, no, it's a very good nit. Thank you for reading it.
There are
Anyway,
important
let me
nits
ask Nick.
sometimes.
Yeah, let me ask Nick a question. What is a classified board? What was that?
So a classified board is a board in which the I believe the directors are not disclosed to the public, or do not stand for election on a no, I'm sorry. It's where the directors do not stand for election on a yearly basis. So where there's a staggered sort of election. So for example, on a board of 12 people, maybe 4 will be up one year, and then 4 will be up the next year. Then the ones who were elected before sort of 3-year or 10-year.
Okay.
Does that make sense?
I got
you. Yeah.
Okay. Thank you.
Typically, it's intended to allow for flexibility and greater adaptability at that board level.
Thank you.
Okay. I will move on to executive compensation. So as Lynn said, yes, that should be fixed in the final proposal. I did add some language up top. I think that the executive comp, it really is intended to align that pay for performance over the long term. And as a long-term shareholder, the board would obviously seek to have that balance appropriately struck. The executive compensation plans can be horribly and arguably unnecessarily complicated at times. But to the extent that the compensation package over relies on short-term incentives or does not, on the same hand, accommodate for longer term performance criteria and hurdles, the flexibility would be, there's a need for some flexibility to vote against those. I will note that executive compensation votes at this point are just, they are not binding shareholder votes. It's an advisory vote. So, in practical terms, you're really just expressing dissatisfaction rather than having an ability to strike down the plan. Again, we added language regarding takeovers. That is some historic language from the prior guidelines. And then again, the added exception here is intended to address compensation plans that do not permit or do not sufficiently address clawback of unearned or misearned executive compensation. To the extent an award is paid out and then it should be recouped, that should be as part of the plan. Other questions or comments before I move to the deletions and other added language? Okay. Deletions. So the employee relations language, again, as Carrie noted here in the memo, it's not a standard provision we see in many proxy voting policies. To the extent that there's a reason for including it, that it doesn't strike me as wrong, but it seems to be a circumstance that doesn't arise much in terms of board level or shareholder voting. So we took it out as old language. Same with the fair pricing provisions language noted on the next page. So, and then finally, I'll turn to the new language that we added. Much of this is meant to address issues that have somewhat come up more recently than I think the last revision of the proxy voting guidelines likely was done. So director compensation plans, generally, it's consistent with best practice to support compensation proposals as long as they don't give excessive pay for board service. And we don't want to have a situation in which board members have their compensation tied to short-term performance, which could result in a misalignment of incentives. The board is really intended to serve as that sort of check on management short-term, board long-term, as a rule of thumb, I should say. So that's language that we've proposed to add there. Proxy access proposals, again, I think that it's consistent with the general view that shareholder access to the director nomination process and access to including materials in the proxy statement is consistent with the shareholder right as a general matter. So in the event that a board is seeking to add proxy access, we view that as a favorable move. And again, standard provisions here. 3%, at least 3% of voting stock for at least 3 years to nominate up to 25% of the board. That's sort of the standard term that we would expect. Creation of tracking stock. Again, I think we would generally want to go against that, reflecting the segment of the business as a whole rather than the company, I'm sorry, the business sector as a whole rather than the company itself could misalign some of the incentives that I spoke about earlier. And then finally, proposals that promote greater transparency and oversight. That's an extremely vague term, and it's vague for a reason. If a proposal is good, we want the board to be able to vote for it. We don't want to make oblige the board to vote for anything or require anything, but we want the flexibility. If the board determines this is in the best interest of its participants and beneficiaries, we're going to vote in support of that. So that's what that language is intended to get to. And I think that takes us through it. Any further questions or comments? I feel like I've been speaking for a long time, but I'm happy to discuss any further items.
I think Mr. Chilton's got his hand raised, so.
Yes.
Yeah, I was interested in some of the controversy that has surrounded proxy voting has to do with being for or against DEI initiatives, environmental initiatives, and similar things like that. How does that work into the thought process here?
So I think we purposely avoided specifically calling out those items, particularly because of the controversy surrounding them. I think that companies are certainly facing greater what do I want to say? Greater or more shareholder voices in the room, and those shareholders may have an agenda they want to push one way or the other. I mean, it does cut both ways, and I think that our language regarding greater transparency and oversight is really intended to get at that. The board should be the capital B board, the Kentucky board, should be able to make its voice heard, but it should also have the right, if it wants, to stay silent or to vote against. It really should be able to vote its mind on that, consistent with the fiduciary duties that run to the participants and their beneficiaries. You know, the duty is to maximize the long-term value of the fund to pay out benefits to folks like that. And getting into the specifics of a DEI or an ESG proposal, number one, I think it's a matter of capacity. Is there a sufficient internal resource to fully evaluate and make an independent determination as to whether any particular proposal should be supported or should be voted against? And those they stack up very quickly. I will say we're wrapping up proxy season here in the U.S. and we have internal teams at other systems of I don't want to say hundreds, but a lot of people reviewing and analyzing these. I think in respect to Kentucky, my understanding is that there's maybe not the same level of internal staffing. So we would want the flexibility rather than an obligation to vote either for or against in that circumstance. Does that address the question? I feel like it's a thorny issue, admittedly.
And I think Vicki Hale, who is our general counsel of the non-advocacy division in our legal department, has something to add to that.
Yeah, I thank you. I just wanted to remind Mr. Chilton and the committee members that in the last couple of years, there has been legislation specifically in Kentucky that prohibits us from specifically looking for or against ESG. We are supposed to vote our proxies solely in the best interest of the beneficiaries and the members. In other words, to make money. We are solely to look for a pecuniary interest. So if there is a proxy voting matter that is, I don't know, I'm just going to say for solar energy, that's going to make a lot of money, we could vote for it, but we are not to consider the fact that it's solar energy or an ESG or a DEI or anything like that. We are supposed to specifically look at the pecuniary interest of the matter, and that is in our statutes. So our proxy policy that we give to our proxy voting company specifically states that, and they are to vote our proxy policy, not their own.
Well, and that's been consistent pre that law. That's how we've operated. So, we'll comply with law, but that's been consistent strategy.
Correct.
So this is designed to give guidance to the company that's actually going to be doing the voting on an issue by issue basis. Our board, nobody within KPPA or KRS is going to evaluate any slates to be adopted or not. The proxy voting service is going to do that, right?
Correct. That we hire a proxy voting service and provide them our proxy voting policy, and they are to vote our policy. And if they have questions, they come back to us. And then, based upon this policy, investment staff can then give them an answer or guidance.
Okay. So who within KPPA, I guess, would be actually giving guidance on the votes?
Yes, so let me direct your attention, Mr. Chilton and Sherry, to PDF page 31, please. And in section 2, It specifically states that the Kentucky Retirement System's Board of Trustees has delegated the responsibility for proxy voting to its proxy voting agent, that third party. And it goes on to state that if the policy doesn't provide specific guidance, there's certain criteria that need to be met. And furthermore, that the board reserves the right for the KPPA investment staff to provide that additional direction to the third party to vote in accordance with the policy, or in limited cases, deviate if there is a fiduciary governance type issue that would warrant that.
So we believe that the language here will be sufficient for the proxy voting advisor to actually make the votes.
I would go back to what Mr. Zeiker said at the beginning. The goal here is to set forth a specific direction to the ISS, to the proxy voting service, without boxing them in to where they have to vote a certain way, regardless of if the circumstances warrant voting a different way, to further the oversight and governance of that investment.
Okay. Thank you.
And I should add, I probably should have given a little more background on Mr. Zeiker when introducing him. He's worked with numerous other public pension plan clients and institutional investors on these types of policies. So he really brings a depth of expertise to, what are appropriate proxy voting guidelines and what will be something that can be utilized by those proxy voting services. So I think we're in good hands here.
And Carrie, just to be clear, so we have hired an external proxy voting service who votes according to this policy that we provide them for KRS. We also have external managers who vote proxies on our behalf, but they also have our policy and they
Yes.
vote according to the
I
policy.
wasn't sure if I should muddy the waters with that or not.
Sorry
but
about that.
I'm
I just
glad
wanna-
that you jumped in to do it.
Sure.
And Carrie, if I can add, we receive the proxy voting reports, so we're able to see how those managers or the voting service has voted to ensure that they voted according to our policy. So it's not just like we send them on their way. There are checks and balances.
And those
Right,
proxy
and I would just
voting
add that-
reports are posted to the website quarterly.
Yeah, that's what I was going to say.
Thank you, Joe.
Let me add that the reality of many of the controversies that hit the press are only advisory. They're an attempt to be an advisory. I don't like Elon Musk compensation, or I don't like the such and such the company is doing. They don't hit the proxy. They take there's a very high hurdle there to be included actually for a vote on the proxy. So while that looks like a proxy or something, a statement that's being made, it doesn't hit the actual vote most of the time.
That I just to add on to that, that's correct. I mean, the proxy voting guideline is, I guess, from my perspective, one tool. And there are a number of other tools to exercise the rights of a shareholder. Engagements. There are, solicitations, which often lead to an engagement with a company, and then that company and the solicitor will then engage in discussions and basically settle before it even comes to the proxy statement. So you're correct. A lot of those controversies, I don't want to speak out of turn, but a lot of them are somewhat overstated for purposes of the press, and they draw a lot of attention and they draw a lot of eyes. But this set of guidelines is intended to function as a tool to assist the capital B board, the Kentucky board, in fulfilling its duties to its participants and beneficiaries. So this is really intended to address matters that come to a vote and are voted upon which are usually, I say usually in very large quotations because there's a range of different issues that can be addressed, but usually they address director elections, they address auditor selection or appointment, and executive compensation. And those are the three that are required to be on each proxy statement. And then, the rest sort of come in on a less frequent basis.
So, sorry for one more question, and that is whether the K board and the C board will adopt identical policies on these things.
If the Kentucky Retirement Systems Board adopt the recommended updates to the proxy voting, its voting guidelines, there will be a difference. Our hope is to work with the KRS board to update their guidelines in a similar fashion so that they match once again.
Okay. Thank you.
Carrie, does that what you needed to
That's
help?
it. So if I may direct your attention to the motion sheet prepared by Vicki Hale, we are looking for a recommendation, a vote in favor of recommending the proposed updates be adopted by the Kentucky Retirement Systems Board. We are looking for a vote to repeal some of the existing policies, and we can enumerate those or just say as listed in the memo accompanying the board materials. And then we're looking for a yay or nay on adopting the recommended changes to the proxy voting policy as detailed in that separate memo in the board materials. So we're looking for 3 items, and with the understanding that I've got a typo or two to fix on page 52 of the board materials.
Lynn, I believe you have your hand raised, but you're mute. There you go.
Okay. I saw that CERS had a meeting yesterday. Did they vote yesterday on the policy? An investment committee meeting yesterday?
They did not. Time was running thin. But again, I mean, this is the purview of the board, the investments, and they'll have the same consideration in the future.
Okay.
They did specifically, they ran out of time. So
Yeah, and to be clear, that what they're considering changing in their IPS is substantially different to this.
Yes.
That's just the addition of a little bit of language. I don't think Carrie has done a tremendous amount of work on this. Obviously, I think the work product is great. And really making this best in class. I think her next objective would be to work with CERS and try to revise some of their policies and bring them up to date as well.
mhm. Yeah, and I agree, and I believe Ramsey has her hand raised. So
Yes, sorry. When I was reviewing the KRS Statement of Investment Objectives and Policies, are we voting on that? What was included there too?
Yes, ma'am.
Okay,
We
can I
will be
just- I'm
voting
just
to
gonna-
adopt that and repeal some of these other policies altogether.
Okay, can I just email you a few notes on that?
I would very much appreciate that. And those will be incorporated for review of the full board.
Perfect.
Yeah, we'll make sure that they get included, and I think it's important. Our investment committee has people who actually practice the trade of investing, and have I think a lot to add to this from their experiences, and so we'll make sure that gets into the process. John?
Yeah, I hate to be asking all the questions, or not all the questions, but it seems to me that there would be some merit to having the CERS and the KRS investment policies as close to the same as possible, just from an implementation point of view for the investment staff. If there are different rules for C investments versus K, it seems to me it's complicated in remembering what the differences are and implementing them. So I'm thinking that it would be interesting to know what the CERS changes might be in order for us to consider making the same changes.
I think the investment standpoint, which a lot of this is obviously focused on, you're absolutely right. I think that if there was consistency across the policies as to how we operated and what we did, that would certainly make our life easier. But we are more than comfortable operating. Currently we're managing different asset allocations between the plans. There's different procedures that already exist as far as presentations, recommendations, and how we go about doing things. So we can certainly operate with it. You're right. It would be more efficient. It would be easier on us, but we're certainly willing, able, and capable of operating. And we do think it's, coordinating with them is great where we can, where you guys can, but obviously you guys, this is your pool of assets, your responsibility. And I think all of the proposals that Carrie's made as far as the policy changes are really the prudent course of action.
And I'll just note, so there are already some differences between the two boards' investment procurement policies. So those differences would be maintained, and some additional differences added, but they're already slightly different. The proxy voting guidelines, that will be a new area of difference. The investment team is operating under slightly different asset allocations depending on the needs of each of the separate funds. So that's not a change. And then everybody's got the same benchmarks for performance, so that's carried over here. So really, the only new difference is gonna be in that proxy voting guidelines, and then some additional differences in the procurement policy, again, which they're already a little bit different. So formatting wise, it looks really different. But I think if you look at the actual details, it's not as big of a change except in those areas noted.
Okay, I believe we have three, Vicky, do we need to vote on the three elements separately, or do we just combine them as presented?
You can combine them as presented. It was just as Carrie had indicated, there was the three different areas. So there's the changes in the proxy voting policy. There's the repealing of the investment policies that are there. And then it is the approval of this new and improved combined, I forget the name of it, Carrie, sorry.
That's okay.
Statement of investment objectives and policies. So since they were all stated, if you get a motion to approve and move to the board as amended, then we can do so.
I would like to get a motion to that effect if someone is willing.
I'll make the motion.
Thank you, Ramsey. And a second? Well, I'll second. Thank you, Pam. So we have a motion, and we'll assume that it is positively voted on unless I hear objections. Hearing none, the motion passes. Thank you all very much.
Thank you very much. And thank you, Carrie, for all the hard work, and Vicky. Thank you.
All Carrie.
Thank you. And, we'll try to not have 3:00 meetings on days that are clear and 70 degrees outside, though.
Yeah.
Can we work that into our planning process?
I leave that on the chair.
Yeah. Thank you all very much for your time. And
I
thank
will
you.
say that
Speaker.
Sherry might shoot you because all the meetings that she had to
Okay.
move around this week.
All right,
I
bye.
know.
Thank you.
Well, that's
Thank
just
you.
lawyers causing trouble.
Yes.
Thank you very much.
Uh-huh.